Appeals, Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in our case number CV220743, Tempe Women's versus Loren. Each side has 20 minutes for your argument. The appellant may reserve some time for rebuttal. I just ask you do that yourself. Proceedings are being audio and video recorded, so introduce yourself and who you represent, who your client is. At the start, we've read the briefs, discussed the case at conference, and are familiar with the arguments raised, so please keep that in mind. I want to put one more thing on the record. Christy Brown received notice, we were told by court staff. She is not here, but again, she did receive notice, so Mr. Abney.
Thank you, Your Honor. May it please the court. My name is David Abney, representing the appellant Tempe Women's Club. The Old Testament says that with God it is all the same to win with a mighty host or with a small company, because victory comes from the Almighty. Well, I hope it comes from this court eventually, but I represent a small company, the Tempe Women's Club. It was unofficially founded around 1911 and officially in 1913 at the height of the Progressive Era. It was part of a flood of civic organizations founded in the Progressive Era that came into existence to push for domestic improvements, civic improvements, public education, and in this case for the betterment of the position of women in society, a fight that is still ongoing and will probably never be complete as long as I live. But it served a vital function. They saved, for over 2 decades, they bought a nice piece of land, about two acres, at the corner of Mill Avenue and what was called Lover's Lane at the time. There was some concern it was too far on the outskirts. You don't have a Lover's Lane, of course, in the middle of town. And now it's 13th. I believe it's called 13th Street. It is good real estate. It is valuable real estate. And a few years ago, a small cadre within the Tempe Women's Club leadership, aided and abetted by a few others, managed to come up with a sweetheart deal to sell the clubhouse property, which is a historic building put up in 1936 by a noted local architect, for $250,000.
Mr. Abney, you say that damages aren't sufficient because the property is unique.
Yes.
What allegations or what were pled and what evidence is in the record to prove that out?
There were discussions at the trial about the uniqueness of the property.
Are those cited in your brief?
No, Your Honor. No, Your Honor. But it is. I hope the court can take judicial notice, if nothing else, that this is a unique historic building, historic property.
Is real property always unique?
Yes, it is, in one sense. Every piece of real estate is different from every other, but this goes beyond that. It's on the Registry of Historic Places, put up in 1936, made by a local architect, made out of adobe block. So it is literally part of the fabric of Tempe.
Is that sort of information in the record?
No.
So
but it's certainly publicly available.
Well, I, as almighty as I might be, I can't go out and just search the internet for information about how unique this piece of property is. So what is in the record that I can rely upon in concluding that this is a unique piece of property?
You can rely upon the opening brief and the newspaper articles cited there from 1936, 1937, and other years that recount the historic nature of the property.
Was that evidence in the record below?
I don't think that's in the record below. Okay. But there again, the court can take judicial notice of these things.
You are the trial attorney?
No, Your Honor.
Okay. Does it say in the record how long this club has been used by this group, that real estate has been used?
I cannot give you a specific citation, Your Honor.
Is there a presumption of uniqueness?
Absolutely. Anytime there's a general presumption that every piece of real estate is unique, and therefore damages for related to real estate are not always appropriate, are not always suitable because they can't match the uniqueness of the property.
And if there's a presumption of uniqueness that attaches to real property, then all your client needed to do was put some evidence in the record that this is real property.
Yes,
In which case, the presumption shifts to the defendants to prove, or I guess disprove, the uniqueness of this particular
Yes.
piece of property.
and I would assume at this point there's no question that this is real property. I mean, we're talking about the clubhouse property, and it's on real estate, about 2 acres in Tempe. So
It sounds like you're not familiar with the record below.
I am familiar with the record below as much as I can be.
Okay, so I'm asking a pretty specific question. In the complaint or testimony, did anyone talk about how long this building has been used by these people?
I do not think that specifically it was in there. I think there might have been some oblique references, but nothing specific that I can recall from my review of the record. But you
And
can certainly take
on the other side of this argument, so there was testimony as to the current value of the property
Yes, Your Honor.
on the side of defendants. Is that
About
correct?
$575,000 was one of the estimates.
Why is that not enough to rebut the presumption that the property is unique? Why couldn't the court rely on that and say, presumption rebutted, this piece of real estate is not unique?
You could put a value on the White House. It would still be a unique piece of property. You could put a value on any piece of property in
Well,
town,
and I
including
guess I
this
should
building.
say, the lower value, I mean, it was what, 575,000?
$575,000 is in the record. The sale was for $250,000.
Right.
$27,000 down payment, $525 a month. For 120 months, no interest.
No interest.
No interest. What a deal. And then the balloon payment of $160,000.
So at or near the time that the trial court is making the rescission decision, the evidence in the record is that the property is worth about $575,000?
Yes. And
Did the court award your clients $575,000
No.
instead of the property?
about $160,000 in damages. The court did
So how
not.
can the court say there's an adequate remedy at law, so I'm not giving you rescission, but I'm also not giving you the adequate remedy at law?
I don't know how you do that. It beats the heck out of me. The thing of it is, that you got a small group of people seize control, and they convince the management that there's an emergency. We've got to sell the property, and they sold it on this incredible deal. And it was inequitable. That was fraud. That was abuse of fiduciary duty. It was aiding and abetting. That's in the record. That's established.
Mr. Abney, in the complaint, plaintiffs were seeking rescission only. Is that fair to say?
No end damages, attorney's fees, costs, the whole kit and caboodle, I believe.
They were seeking damages?
I thought so.
Can you point me to that? It seems to me that rescission is the only relief sought.
Well, I
If
don't,
that's the case, just indulge me for a minute, then could the court order damages instead?
yes, I believe so. I believe it's in the complaint. And certainly by the time we get to the
No,
end
but
of the bench trial.
assuming it was not, assuming that only rescission was pled, could the court award damages instead?
Yes, by the time you get to the end of the bench trial, the court has reached the point of saying that this is an available remedy here, and this is the remedy I'm going to apply, which is damages, which is one of these laugh all the way to the bank kind of awards, because everything's confirmed, the case is over, the appeal's done, they win what they win, but they still have to pay $160,000 or so in damages. So what? They sell the property for vastly more than anything they put into it. They pay off these damages and still come out with a princely profit.
Doesn't the plaintiff get to make the election of remedies, not the court?
No, well, you can ask for remedies, but the court's the one that's going to say, this is what I'm going to do. Which, the thing that puzzles me about this whole thing is, why not order rescission and restitution? The judge says, well, I can't do that because I don't think you've got enough money. But you're talking about an organization that came up with the money in the middle of the Depression to buy a nice piece of real estate, to put up a building that has been in existence since 1913. They're going to come up with the money if they possibly can. You should at least give them the chance. And if you can say, well, you can't have restitution, I don't think you could afford restitution, well, why not shackle the defendants with the same sort of deal? So you repay the $27,000 down payment. You pay them $525 interest-free for 120 months. Then you pay them their balloon payment of $160,000. That's what they wanted to do to you. That's what they did to you. Do it to them. That's even-handed,
What do you
isn't
do
it?
with the liens that were put on the property?
Well, there's tax liens. I know that because I had to investigate that recently. Those going to have to be dealt with by the owner. But they're the owner technically right now of the property. They're responsible for routine maintenance. I don't see how they possibly get reimbursement for routine maintenance that's occurred. It's their property. And for any improvements that they've made, well, then the trial judge can say, okay, you've made these improvements, these are lasting capital improvements, and they should be paid for by the Tempe Women's Club.
Right, but if I defraud you out of a piece of property and then I go lean it up, if a court orders rescission, I should both have to give the property back and give you the funds required to pay off the liens that I put on the property, right? So then you have both rescission and damages. Those are not mutually exclusive.
No, and you've got a very weird situation here. The managers of this cabal that seized control, supposedly made a whole bunch of loans secured by the property. A huge amount of money went into that, $240,000 or something like that. But this is all them profiting from themselves, and in the end, of course, they get paid off, and they all pocket more money, and everybody's happy. They're happy, but the Tempe Women's Club is deprived of the property. And I hope the court will take judicial notice. I'm officially asking that this is an historic building. I mean, it's in the opening brief. There's support for that. Newspaper articles can be regarded as a source of judicial notice. This is something that's important. It's unique.
So is value, meaning the cash value, the only component of unique as an adjective? Or is it unique? Can it be unique in the hearts and minds of members that makes it unique?
Well, it's certainly unique in the hearts and minds of members.
Is that cognizable
Yes.
when defining unique?
Yes.
And is it appropriate for an appellate court to take judicial notice of any fact, or is that something that the trial court could have done? But
Trial court
is it
could have done
appropriate for
it.
us to do that?
Yes, Your Honor, I believe it. You can take judicial notice at any stage of the proceedings, including on appeal. And if I had been handling the case, I would have. I am a historian. Actually, I have a PhD in American history from good old ASU. The first time I came into contact with this case, I said, let me look into the history of this organization, because they were telling me we've been around a long time, and I verified they certainly have been around a long time. They're part of the fabric of Tempe history. They're part of the fabric of Arizona history. This organization matters. Their building matters because it is historic. It is unique.
Yeah, but it would have been very easy for the club to call its president as a witness at trial to testify to all the great things you're talking about now, but that didn't happen, did it?
No, Your Honor. You know, some people have a bent for history and some people don't. I look at everything through an historical lens. It doesn't always help with cases.
Well, as a lawyer, you should have, I'm not talking about you, but you should have a bent for the law, and when the law says rescission needs to be unique, one would think that, having a bent for the law, that you would go out and muster the evidence that you would need to prove that particular element.
I cannot cast stones. I have forgotten or overlooked things in the past too, but
Well, we're talking about an element of a claim. It's different than an appreciation of history.
it's not so much an element of the claim as further support for uniqueness of property. Real property is, every parcel is unique.
What's the further? There's nothing in there, in the record, unless we take judicial notice, is what you're saying.
Yes, and I asked for judicial notice from the court. This is part of history. You could crack any history book of Tempe. You could certainly look at the newspaper articles that I cited for support.
And Mr. Abney, I just want to be clear, because we have a by our standards, a fairly packed courtroom today, or a lot of people here today interested in this case, and we're not questioning whether it's a historic piece of property. The point is that evidence was not offered at the trial court, and we are a court of review. And so that's the concern that we have, whether it is appropriate for us to take that fact-finding step. I just want to be clear for everyone's benefit.
Yes, Your Honor, I believe it is appropriate. This is something that it's easily verified, and I did verify it, and I provided that verification in the opening brief. If you want any supplemental briefing, I could further verify it. But Tempe Women's Club is an important organization, and it has been since 1911. And the building has been there for 87 years or so now. But
Let's assume that there is evidence in the record, or it was pled, that this organization has used this building for over 100 years. Is that sufficient to prove uniqueness?
Well, as Judge Catlett said, any piece of real property is unique. This adds a layer of uniqueness. This explains and provides more context to exactly why it's unique.
So does this make it more unique?
Yes, Your Honor, it does. There's nothing like this building. I mean, it is not the Taj Mahal. It's made out of basic Tempe materials. It's a basic, strong structure. It has somewhat of a unique appearance if you look at it from the outside. But it is an historic structure. And I think that matters when you're trying to evaluate what to do. Damages are not going to be sufficient. Even if it was not a historic building, even if it was not a building that they've been using for 87 some odd years, it's still a unique piece of property. You cannot just say, here's some damages, go away. These people defrauded you. They stole the building from you. They're going to stand to make an immense amount of money, and I'm not going to order restitution rescission and restitution because I think you can't afford to pay it. Well, give them the opportunity at least. Come up with some sort of equitable plan for repayment of whatever has been justly paid so that it can be given back to these folks. Iron out whatever damages, iron everything out. I mean, if you talk about the damages that have been awarded and the restitution they're seeking, there's a whole lot of money there that you can balance things out with.
Okay, so the court denied rescission based on four main reasons, and you're talking about one of them, the perception that the club would not be able to pay to make rescission just. Was that an abuse of discretion, or was that legal error?
It's legal error which constitutes an abuse of discretion.
And how is it legal error?
Because there is no requirement in the law of equity and the law of restitution that you have to investigate the ability of someone to make repayment. When you order rescission and restitution, you order rescission and restitution, and if it's fulfilled, everything's fine. If it's not, then you go on to the next step. What do you do? What do you do now since you can't make restitution?
All right. One of the other reasons why the court denied rescission was that according to the court, the club waited too long in seeking rescission, right? 2 years. Talk to us about why that was legal error.
That's why I went into the facts. So, I mean, the facts section here is enormous in compared to the legal argument section, because I was trying to unravel the threads of what they had done. These people hamstrung the management, the proper management of the Tempe Women's Club for month after month after month. And so it was hard to tell who was in charge, whether these folks were in charge or whether what I call the good people were in charge. And it took a long time to get that ironed out. And as soon as that was ironed out, they filed the lawsuit and filed the lis pendens, which is an incredibly important thing to do here.
So what is the time gap there? What is the time, according to you, what is the time delay?
If you take it all in all, I think it really comes down to a few months where where the good folks had control, had knowledge, and were able then to act. But you have to go through the entire timeline to see what was happening. There were elections.
That's the February date, I think, that the trial court found where it was finally clear who was in charge of the club here.
I think it was a little later than that, but there was
an April date too,
yeah.
I think.
But you had problems. You were trying to assemble quorums, who was entitled to vote, who's not entitled to vote, who's in charge, who's not in charge, who has knowledge, who doesn't have knowledge, and all these things took a long time to iron out. And when it was ironed out, they moved.
In the little time you have, can you talk to us about why the doctrine of unclean hands should not have been part of the equation?
Yes. Unclean hands, you are doing bad things in unclean hands. It's not stupidity, or it's not a failure to appreciate what's in front of you, which is sort of what was going on here. The good folks simply did not understand fully what was happening, in large part because of the dirt and dust that these other folks were kicking up, trying to confuse the whole process.
So give an example of where unclean hands would apply here. If your clients were also committing fraud?
Yes, or if for instance, they thought that the property was worth $125,000 and this $250,000 is a windfall, and they're really happy to go along with that for a while until they discover something else is going on. But there's no unclean hands here. There's simply a failure to appreciate the wrongdoing that's going on, and you can understand that. These people are supposed to be cooperative. They're officers. They have fiduciary duties, and these folks are confusing the good folks about what the heck is going on. Finally, the clarity comes, and they file the lawsuit and the lis pendens, so they can go into court and try to get this ironed out, and then really obtain rescission and restitution. The property belongs with the Tempe Women's Club.
Why are the damages not sufficient?
Well, the property is unique. Damages will not make up for that. The damages that are awarded, of course, are very modest, but the property itself is something different. Now,
So your position now is that no amount of damages would be sufficient?
Gosh, I hate questions like that. Yes, I will say that, although I think $100 million, they might take that and maybe reconstruct the clubhouse on a different piece of property. But no, no amount's going to matter. They need to get the property back. It's their clubhouse. Oh my gosh. I've got a few seconds left. I'd like to reserve those.
Okay, thank you.
Thank you.
Mr. Taylor, before you start, I'll wait till you get up. You're here today representing only yourself, right?
Well, I'm here to present the oral argument, but yes, I'm representing myself at the trial level.
Okay, so keep that in mind when you're making your argument, that you're here pro per.
Right.
You can proceed.
Okay, and just on that point, and we went through this in the trial court level. It was pretty much decided that my aiding and abetting claim is addressed by almost all of the issues before the court, except for maybe Kathy Pippin's aiding and abetting claim.
All right, was there a rescission claim brought against you?
Well, not insofar as damages, but yes, I'm liable as an aider and abetter to contribute to the damages.
But you're not on title
No,
of the property. You can't give it back.
no,
So that,
but I do.
the remedy does not run against you.
Well, it does in the sense that I loaned money to the club, or to the Tempe or Clubhouse LLC that bought the property. I loaned them money, so I have a lien on the property, and it's been the club's position that I should lose that lien as part of the rescission. So it does affect me in that sense.
All right, well, we might give you some guardrails here,
Okay,
but keep in mind that you're here pro per representing yourself. Proceed.
okay. I don't know if I introduced myself, Frederick Taylor, for myself, but representing the appellees and the cross appellants.
Counsel, just a moment. We're trying to be delicate about it, but
Yeah.
what is the status of your law license?
Is currently suspended because of this case.
So you are not able to appear on behalf of anyone except yourself.
Right, okay.
Okay, so you're not here on behalf of the remaining appellees. That would be unlawful.
Right, it's just my understanding that someone had to represent all the parties at the podium here.
And that may very well be that the other parties may want representation, and Attorney Christy Brown has appeared in the case and is not here today. We don't know why. Jody Loren appeared in the case pro se, and Kathy Pippin appeared pro se. They've not requested to be heard, so you can only address matters that directly relate to claims against you. Let's just remember that, okay?
Okay, all right.
We have the briefs, but
And I'm sure you'll let me know when I get
Okay.
off track here.
We'll try.
Okay,
Yeah, it's not really our job to make sure that you comply with your ethical
sure,
duties. So
right,
sure.
it's the bars, but go ahead.
In my preparation for this oral argument, I reviewed the transcripts that were recently provided, and interestingly, those transcripts confirm what was also apparent in the plaintiff's case pleadings. That is that nowhere did the club claim that it needed to regain ownership of the property so that the members could again begin meeting there and resume paying the expenses of owning and maintaining the building. Nor did it really claim that in their appeal brief. They've never expressed an interest in utilizing the property while the trial was pending for 3 years. Even one of the judge's findings mentions that Ms. Loren should have advised the board that there was time to obtain an appraisal and sell the property before the foreclosure date. That finding is inconsistent with what they are now presenting as a preservation of the property request.
And how does that finding tie into the aiding and abetting claim that was found against you personally?
The finding, again, aiding and abetting is dependent upon, or my aiding and abetting liability is dependent upon Jody Loren having committed some type of fraud or some other tort and fashioning whatever the damages were. If she's not responsible, then I'm not responsible. And depending on what the damages are, since I'm also on the hook for those damages, I think that ties it in. Anyway, I think what is clear that everyone knew that if Ms. Loren did not sell or that if the club did not sell the property to Ms. Loren, that it needed to be sold to someone else. And so consequently, I don't think that the club's claim today that it was a unique piece of property that needs to be preserved because of its historic interest, which is a claim that has been raised for the first time on this appeal. I think it's irrelevant because nobody was going to keep that property. And it should be noted that the club is thriving without the building. In fact, Marcia Patton, the club's representative, testified at trial at that time that the club had approximately twice as many members as it had in April of 2017. So that financially and membership-wise, the club seems to be doing just fine without the building.
So, counsel, what's the error in the aiding and abetting claim?
Pardon?
What is the error below on the aiding and abetting claim?
The error?
Or why isn't there an error?
Well, as I mentioned in my brief, the one error was the statute of limitations. That being that I was not listed as a defendant until the first amended complaint.
Can you talk about that, please?
Yes, that occurred. The original complaint was filed on April 18th, 2019. No mention was made of my role either directly or fictitiously as a fictitious defendant. The plaintiff filed an amended first complaint on September 16th, 2019, and for the first time listed me as a defendant and made the allegations of aiding and abetting. And it's my position that the statute of limitations should have begun running either on April 5th, 2017 is our position because that's when the sale took place, or the close of escrow on April 4th, 2017. And so you run the time out, and I believe it's a 2-year statute of limitations of aiding and abetting for a fiduciary responsibility. And so 2 years later brings you to April 2019, plus in some instances, Rule 12 or 15C2 allows exceptions where you can also tack on the 90 days allowed in Rule 4I. That still falls short of September 16th, so that the statute of limitations had run by the time that first amended complaint was filed.
Did you include the statute of limitations issue you're talking about as an issue of law that the trial court would need to dispose of in the pretrial statement that was filed with the court?
It was raised twice, as I recall, one in a motion for summary judgment, and also in, trying to think of it, I believe it was in the pretrial statement, otherwise it was in the post-trial findings of facts and conclusions of law.
Yeah, I looked at the pretrial statement. I didn't see it in there.
Okay, then it is in the proposed findings of facts, statements of law.
I also looked at the motions for summary judgment, and it looks like there was a motion based on statute of limitations filed with respect to one of your co-defendants, but I didn't see in any of those motions that your argument about statute of limitations had been raised. Am I wrong about that?
My recollection was that it had been. I know that it was raised, the issue in general was raised in the first motion for summary judgment.
But don't you have to at least include it in the pretrial statement, particularly in a bench trial where it's the court that's going to be hashing out all the issue? How did the trial court judge know that this was something that he was supposed to decide? I mean, he's got a large docket. He can't possibly be expected to remember, if there was one, that a motion for summary judgment had previously been filed on the issue. So I'm just wondering why it's sufficient to wait until the post-trial briefing to raise the issue and not include it in the pre-trial statement.
Well, I guess I assumed that since it had been listed as in a motion for summary judgment, that it was still before the court, and that, again, there hadn't been any findings before the proposed statement of facts and conclusions of law was filed. I mean, that was an opportunity to present issues and facts to the judge for him to decide.
Are you arguing at all that you weren't properly served?
No, that had nothing to do with anything. My argument there was simply that to try and show a date upon which I received the notice. And I wasn't properly served, but it was mailed to me. So the point is that it was sometime after September 16th that I first received notice of that I was a new defendant in this case. If I could continue on rescission, another issue that the review of the transcripts shows is that the club has vacillated throughout the litigation on whether or not there needs to be an offer to return the parties to their original position, pre-contract position. Women's Club asserts that a demand for a rescission is satisfied by demanding a return of title to the property only, and that is not really the standard. But even if it was, as we've noted, the Women's Club demand was set forth in the first time in the complaint, and defendants didn't see the complaint until over a month after it was filed, because the Women's Club kind of sat on it for a while, not even issuing the summonses right away.
How was your client prejudiced by any delay that might have occurred in seeking rescission?
Well, I think that what you can say is that for instance, in this case, having obtained title to the property, they instantly began investing in that property. They spent tens of thousands of dollars, improving the property, maintaining it, paying off old debts. And had this issue been brought up much sooner, I think the defendants could have put a stop to things. There could have been an opportunity for settling the dispute, certainly. I mean, after you file a lawsuit, everybody kind of digs in their heels, at least for a while. But if it would have been raised at a much earlier time before the defendants had invested a lot of money in the property, things could have been resolved.
The trial court seemed to peg the starting date for calculating the amount of delay at the date of the sale that's challenged in this case. Is that right?
For the delay in
seeking rescission.
Yes, I think the court did look at it from that angle, yes.
We have a case called Carruthers that talks a little bit about this issue, and it said, we said in that case that the court wrongly defined the delay period as the time between the July 2006 stock sale and the December 2008 letter offering full rescission. This was error because the proper starting point for the calculation was not the date of the sale, but the date that plaintiffs knew of the alleged fraud.
Okay.
Why do we not have that same error in this case?
Well, I believe that was a securities case, and it seems to me the courts kind of treat those a little bit different. But the second point would be that if we do change the date to when the plaintiffs became unhappy with the fact that Tempe Clubhouse was going to sell the property, that would have been in October of 2018. They went and talked to an attorney in November of 2018, and then so it was another.
We have a finding from the trial court that Mr. Abney's clients were not in control of this property until February of 2019, right?
Yes.
How do we get around that finding? Because to me, that seems like where we should start our calculation on delay, because prior to that, what we're concerned about is the entity, right? The entity has a separate existence from the members who are involved with the entity. If the entity is still controlled by those who have alleged to committed fraud until February of 2019, why is that not the correct starting date?
Well, for a couple of reasons. One being that if these board members really felt that there was an issue, they could have brought a derivative suit. And two...
For rescission?
Yes. I don't know anything that would prohibit them from bringing such a suit, because they're really speaking on behalf of what's the best interest for the club. So I don't know. I don't see whether there would be a distinction. But two, there are some specific Arizona statutes that I've cited in my brief.
Just a second, counsel, because I was tracking and missed a step here. You're saying that even though Ms. Loren was and her supporters were in control of the club, before the February date, remaining members could have brought a lawsuit on behalf of the club?
Yes, a derivative lawsuit.
Well, for purposes of a derivative action, it's not enough to be a member of a club. You have to be a member of the LLC. So which of these plaintiffs were members of the LLC that had a sufficient ownership interest where they could have brought a derivative action? It's not enough to be a member of the club.
Okay, well, they weren't members of the LLC.
Right.
And secondly, I've cited statutes in my brief that talk about allowing board members to bring causes of action to ask the court to, for instance, oversee the voting of a company, a nonprofit company like this. I think there were some options there. I don't have the citations right in front of me, but I believe it was in my opening brief. Getting back to,
I mean, just zooming out at a very high level of generality, ultimately, at the end of the day, what the court did below was said, I'm not giving this property back, I'm giving the club instead $162,500 for what happened here.
right,
At a very high level, how is that an equitable result here?
well, because the court found that the other board members shared responsibility for this property being sold that day. I mean, no one was requiring that the offer that was on the table be determined that day.
Yeah, but I think, aren't we past that once he finds that they were defrauded?
Well,
There was fraud here.
yeah.
Okay, so, and that finding has not been challenged on appeal as, coming along with
Right.
insufficient evidence or something. So we're stuck with, there was fraud here. So there was fraud, it resulted in this property being conveyed to someone else,
Yes.
and then what we have is a damages judgment for $162,500. How is that equitable?
Okay, the 162,000 plus the 250,000 that they are receiving in payments from the defendants. Plus, again, the fraud, I mean, yes, there was fraud found, but the judge also found that there was no reason for these other board members to hurry a vote without looking into anything. The judge found they had a responsibility to consider some of these issues that were presented to it, and even they voted unanimously. A week later, they voted again unanimously to accept this offer when it was an open-end offer that they could have done all sorts of investigation prior to even voting on it one way or the other.
Right, and at that time, the club was your client, right?
As far as being, well, that's a whole different issue, but I have...
Well, I don't know that it is, because it feels to me like we're in problematic territory here with...
Well, I wasn't there when the vote happened. I wasn't there when they even talked about having a vote. I was there, I was hired by the club for a specific purpose to address the termination of the treasurer and the president, and after that happened, I was looking for a way to exit the meeting. As soon as I saw there was overlap between that issue and talking about how to address their monetary problems. So,
Thank you, Mr. Taylor.
okay.
Mr. Abney, you have 25 seconds.
All right.
I believe I'm limited to what the gentleman on the other side of the aisle talked about. So the trial court said you don't have any cause of action until you suffer the damages. But it is a good point that you didn't have the right or ability to sue until my folks were able to get control more or less in February 2019. Then they filed in April 2019. That's pretty fast considering what was going on. So I submit that the statute of limitations is not a bar here. Thank you, Your Honor.
Thank you both.
Sorry it took so long.
Thank you both for your argument. We appreciate it. We will take it under advisement and have a decision out in due course. We are adjourned.